that placing women at the centre does not mean that states should ignore fetal interests. And I think that is a very important point, and I'm wondering, could you maybe elaborate on that? How, say, could a state like Ireland protect both women and fetuses in the context of abortion law, and what is the best way of doing that?
Thank you. I'll go to your first question about grounds-based regimes and how they function. The only country in Europe, and when I say Europe, I mean the Council of Europe, so the 47 Council of Europe member states that has a minimum grounds-based regime that international human rights law speaks to is Poland. So Ireland has the second most restrictive law in Europe. Malta has a total ban, Ireland has a life exception, and Poland has these 4 grounds. And in each, the European Court of Human Rights, the cases that were referenced earlier by the Equality Commission, there are 3 cases before the European Court of Human Rights in regards to Poland's abortion law. And those were cases challenging, not asking for an expansion of the grounds, but the fact that these 3 women, separate cases, and 1 girl, did not get access to lawful abortion services in Poland. And in each of those cases, one was a case concerning a woman's health, one was a case concerning rape, and the other case was a fetal impairment case, which is essentially the grounds in Poland. And in each of those cases, women weren't allowed to access abortion. And in each of those cases, the women that experienced those violations were vulnerable women. One woman was a woman with a disability, another was a child, and another was a low-income woman. These are the people that restrictive laws impact. But basically, in each of these 3 cases, the court found violations of the European Convention for state failure to actually implement its law. And the court said, a right cannot be theoretical or illusory. It must be real and practical. And the state must put in practical measures so that women can access lawful services, and it didn't in these cases. And in 2 of the cases, the court found a violation of inhuman and degrading treatment for not actually allowing the women access to lawful abortion. It's very difficult to regulate a grounds-based abortion regime because they're usually, first of all, exceptions in the criminal code. So there's criminal liability, which creates a chilling factor. But it's also very difficult for the legislature to define specifically what a health risk is, and human rights bodies haven't done that, and neither has the European Court of Human Rights. And they tend not to go into a medical analysis of whether or not there's a health risk. They just don't like doing that because most of them are lawyers and not doctors or healthcare providers. So yeah, I think in every country, in New Zealand, they have the minimum grounds-based approach, and human rights bodies have heavily criticized New Zealand for its multiple provider authorization, kind of like they have something similar to the Protection of Life During Pregnancy Act, where you have to have numerous doctors approve, far less than Ireland's, but still they do have a requirement where numerous doctors have to approve. And it really impacts rural areas where the doctors just aren't available to approve. The CEDAW committee has called it a convoluted law that basically strips away women's autonomy and doesn't grant them really the right to abortion in the cases provided in New Zealand.
I suppose reasons-based legislation is kind of out of kilter, or certainly increasingly so, in terms of international best practice from the point of view of complicating access, and that the issue of accessing healthcare services is where the starting point is, which I think is something that the Human Rights and Equality Commission had that view, that we look at this from a health point of view.
Yeah, well, human rights bodies are increasingly recognizing that grounds-based laws actually create harm to women, right? So you have these recommendations that I had mentioned in my paper and are outlined in the detailed paper I think that you received, that show that they're actually calling for first trimester abortion on request. That's clear, and human rights bodies, the Children's Rights Committee, isn't delineating the grounds. They're just saying ensure access to safe abortion. So we're increasingly seeing a recognition of the problems with the minimum grounds approach.
So in the context of access to safe abortion and, say, an Irish context, the option of travel, which was used as before, could you maybe, is clearly insufficient?
Well, no, I mean, human rights
to vindicate
are supposed to
women's.
be implemented in the country.
It's insufficient from the point of view of vindicating women's rights.
Absolutely
just having
not.
the option to travel, or some women having the option to travel, and it introduces, I suppose, an extra discriminatory provision there.
Oh, absolutely.
Response, I think we need to bring, because I've given you considerable latitude. Yep.
Yes, and the Human Rights Committee in the Mellon and Whelan cases were very clear on that. Travel actually caused further harm as well, that the woman was not treated equally like any other patient would in any other healthcare situation in the country, and she was stigmatized and forced to leave the country because of her condition.